I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into number 56 of our compilation series. That's right, number 56. We're going to be in 4 different judges' courtrooms. Before I give you the rundown on those judges, just a little FYI, there will be no commentary added to this video. Also, chapters will be added for your convenience. And so let me now give you the rundown of the judges' courtrooms that we will be in. The first judge courtroom we will be in will be that of Judge Hudson out of the state of Texas. Next, we will be in the courtroom of Judge John Sanders out of the state of Illinois. After that, we will be in the courtroom of Judge Chad Crum out of the state of Kansas. And last but not least, we will be in the courtroom of Judge Shawn Perkins out of the state of Michigan. As always, I appreciate you guys. Thank you for commenting, subscribing, sharing, liking. It has really been a blessing to this compilation series. So listen, let's go ahead, guys. No more talking and jump into number 56.
Mr. Bishop, we have the defendant Vincent Luis Haynes. He's facing 2 charges: expired registration and failure to maintain financial responsibility, and a motion to dismiss. Mr. Haynes, can you please, there you are, Mr. Haynes, there, unmuted. All right. So, Mr. Haynes, do you wish to summarize your motions at this time?
Yes.
Go ahead, sir.
In my notice of abatement, I am asking for the court to show that it can uphold the Constitution in reference to Article 6. I am basically stating that I am a natural person. You know, I'm in the court even currently right now with my Lord and Savior Jesus Christ, and the notice of abatement just goes to the heart of the matter as to the jurisdiction, both subject matter and personal jurisdiction, and to make sure that these proceedings are done to assure equity and fairness. I realize that this court may not provide a remedy for me, and so at that point, I'm asking for adjunctive relief if that would be appropriate.
Mr. Haynes, you're using terms that are civil terms. This is a criminal court. These are Class C criminal charges, which carry a fine as their punishment. This is not a court that gives a remedy to a defendant. You are charged with a citation. You are charged with a crime based on the actions of a police officer.
Who did I offend?
No, sir, hang on. I'm not done.
Okay.
So I want to make sure you understand you're using civil terms. The rules that apply in this court are the Texas rules of criminal procedure. And those are the rules that dictate how the hearings and trials will proceed. And it is the Texas laws which grant this court jurisdiction in these matters. I'll make sure you understand that. If you wish to continue to summarize anything, you may, but I want to make sure you understand you're using civil terms. This is a criminal court.
Okay. Even in a criminal matter, ma'am, I still have a right to face my accuser. Again, that's what the abatement was about. And who accuses?
Sir, hang on a second. You haven't gotten to that point yet, because this is a first setting, and if you plead not guilty, there will be a trial. But as you've seen here tonight, many people plead no contest or are guilty. Therefore, there is an opportunity to hear and have all the accusations presented in court. You just have not gotten there yet.
Yeah, I don't understand that.
Okay. Well, Mr. Bishop, does the state have any response to the abatement motion?
Yes, and I'm just seeing this motion for the first time tonight, but it appears he says that the court lacks subject matter jurisdiction over this ticket, and therefore the action should be abated. And I'm summarizing that. The state's response would be that this court has jurisdiction to hear citations for traffic violations and Class C misdemeanors in the city of Dalworthington Gardens. And so it appears these tickets were all alleged to have occurred in Dalworthington Gardens, and therefore we respectfully request that the defendant's motion be denied.
Your motion for abatement or notice of abatement,
It's a notice.
your notice of abatement is filed, sir, but there's no action that this court is going to take at this time. And you have filed a motion to dismiss. Before we go into that, sir, there's a couple of things that I want to make sure to put on the record. You've been here in the Zoom courtroom tonight. At the start of court, I went over rights and options that defendants have. Did you hear those rights and options, sir?
I heard the rights and options that's pertaining to those particular defendants, yes.
Yeah, that was to every defendant set here tonight. Do you have any questions about those rights and options?
I mean, I don't understand them pertaining to me.
Well, they pertain to you because you have received a citation and you're charged with this offense. You may not agree with it and you may not like it, but they apply to you because you were in the city of Dalworthington Gardens and received these citations. So that's how they apply to you. Now, as I warned everyone at the start of court, you have the right to be represented by an attorney. And if you wish to have time to consult with an attorney, please let me know and I will give you a pass until next month's docket. Otherwise, if you do not have an attorney hired to represent you, you will be held to the same standard as if you were an attorney. So at this time, sir, do you wish to represent yourself or do you wish to have a continuance to consult with an attorney?
I'll represent myself.
Okay. All right. All right. And if you do not have any other questions about the rights or options that I went over at this time, we can proceed now to the motion to dismiss. If you wish to present that at this time, you may summarize your argument for the court at this time.
The motion to dismiss comes from the fact that I put a notice of abatement in, and I never got a response from my notice of abatement. Just basically asking the court, for its jurisdiction. You're explaining how your jurisdiction kicks in, but it's not relating to what I'm saying. I don't go by misnomers, and I seek, the honorable court to apply fairness, and equity. This court does not state whether or not this is a court of equity. You're telling me right now that this is a criminal court. You're saying that this is a criminal case, and you're not really presenting a crime that I see that would be tantamount to criminal proceedings. But again, everything is laid out in a motion to dismiss, and I feel that it is warranted because the court does lack subject matter and personal jurisdiction in this hearing.
Response from the state, Mr. Bishop?
Motion to dismiss should be overruled, Your Honor, or denied. State has jurisdiction here. This individual was using the roads or highways of the state of Texas. And by doing so, as his driving being a privilege, not a right, was bound by the laws of the state of Texas when driving. The allegation is he has violated those laws, and so this court would certainly have jurisdiction to hear those citations. I believe there are two of them. One is registration. The other one is failure to maintain financial responsibility.
Court has reviewed the written motion to dismiss, has heard the summary from the defendant, Mr. Haynes, response from
I object, Your Honor.
I'm sorry, sir, what did you say?
I said I object.
To what, sir?
Because there's no city, state, or government that should make a rule or law that abridges my right to the freedoms and the privileges of the continent or the land of the United States. I'm a natural born man.
Okay.
And
That,
I
that
have,
objection, sir,
I
that
have a
objection, sir,
constitutional right to be.
sir, sir, I've heard the objection. Your objection is overruled. All right. Your motion to dismiss is denied at this time. The allegation in the citation which you signed states that you committed 2 violations in a location that is within the territorial limits of the city of Dalworth Gardens.
You have the actual
county,
ticket?
Sir, you need to be quiet and listen. Within Tarrant County, within the state of Texas, that establishes subject matter jurisdiction for this court to hear this matter. The court has not made any ruling in regards to guilt or innocence at this time. However, that does give the court authority to hear this case. Therefore, your motion to dismiss is denied at this time.
Do
Now,
you have
sir,
the actual ticket, ma'am, that I mailed back in?
I don't know if you mailed it back in or not, but I have the copy that you received notice at the time and that you signed it. And that is all that is required.
I signed it under duress as well.
All right, sir, are you ready to proceed to trial tonight on your cases?
Proceed to trial tonight?
Yes, sir. This is the contest docket. You've indicated you wish to represent yourself, and you are facing the 2 charges of expired registration.
I need
and
to have
failure
a
to
trial by
maintain-
jury, ma'am. It's still, everything is
Okay, well,
before.
we're going to get to there. So to the charge of expired registration, how do you wish to plead, sir? Guilty, no contest, or not guilty?
I make no plea, ma'am. I'm not pleading. I do not accept your jurisdiction.
Well, that's the step to getting set for a jury trial, is if you're going to plead not guilty. Are you pleading not guilty and requesting a jury trial?
There's no plea that I'm making.
Therefore, the court will enter a plea of not guilty for you. And you've indicated you wish to have a jury trial. Is that correct, sir?
The jury trial, yes.
Okay, so enter a plea of not guilty, setting you for a jury trial. So we're going to set you for a pretrial docket, and that will be September 3rd at 7 p.m. You will get a written pretrial order. You need to read it over. It explains what you need to do and the timing. If you have any motions that you want the court to hear as far as discovery or anything of that matter, that needs to be filed at least 14 days before the court, before the pretrial hearing. If you have any evidence you wish to be able to present to the jury, you need to have that marked and filed with the court according to the pretrial order. Once we have the hearing on September 3rd, you will be scheduled for a jury trial, which we have during the day. So make sure that when you come on September 3rd, you're aware of your schedule and any conflicts that you might have for September and October.
Thank you.
You will get a written pretrial order and you'll get a reset notice. We'll see you back here on September 3rd at 7 p.m. You are released at this time unless you have any question regarding the scheduling, sir.
You say back here, this is going to be on a Zoom call again?
Yes, the pretrial will be on a Zoom call. Yes.
Okay, and I'll have instructions relating to all of this as well.
You'll get it all in writing. It'll be signed by me, and you should receive it early next week, if not earlier.
All right.
Okay. Just watch your email, check your spam folder, because there will be some attachments, so they might go to spam or junk if you have that. All right.
If I have any questions, I'll make sure I call your clerk.
Call, or you can send them in writing, either way. All right.
All right.
Okay. This concludes your hearing. You're released at this time. We'll see you back for your pretrial hearing September 3rd.
Yep.
Are you Mr. Hanna?
Yeah.
All right. This is case number 2024 CR 420, State of Kansas versus John Hanna. Mr. Hanna, it looks like you've been charged with 1 count of sexual battery. That is that's a Class A misdemeanor. That can carry up to a year in the county jail and a fine of up to $2,500. So let's talk about how you might want to handle your case. This is just the time just to let you know what your charges are. Did you get a copy of the charges against you?
Of course not. I haven't even been found guilty on the sanction, the write-up while I'm in here.
Well, of course you're not going to be found guilty yet.
But I mean, I don't mean to interrupt you, but that's the procedure. And I mean, we could talk to the Department of Justice about the jurisdiction of the case as well. We can take it to that extent, but you can go ahead and continue. I would like to challenge the jurisdiction on the charge. I want to state that for the records as well. Will you continue? My apology.
Mr. Hanna, I'm going to run this court, not you. And you can start off with the sovereign citizen crap about jurisdiction and everything else if you want to.
I'm saying, I understand that. I'm just saying, but
it's not going to
talk
get
to the Department of Justice as well, because you know who the director of the Department of Justice is, right?
That's just fine. You can do whatever you want.
We'll talk to him now.
Anyway,
He'll be waiting on an indictment on you.
In any event, you're charged with one count of a sexual battery, Class A misdemeanor. Are you going to have an attorney to represent you, or do you want the court to appoint somebody to represent you?
You can appoint me one, and I'll have an attorney later on when I find one.
Okay, I'm going to go ahead and give you a hearing date on the misdemeanor control docket. Your next hearing is going to be November 18th at 9 o'clock with Judge Webster. That can be by Zoom. Mr. Canfield, what's the state's recommendation on bond here?
Your Honor, in addition to the sexual battery against a deputy, the defendant also has been convicted of aggravated domestic battery, and aggravated escape from custody. So at this time,
on those cases,
the state's recommendation will be a $7,500 cash or surety bond.
those charges aren't even my record. For legal detainment and Orbis,
Very well. The court's going to go ahead and set your bond at $7,500 for security.
Maybe he's facing the grand jury.
If you can, sounds like you can afford your own counsel, so I'll let you go ahead and see about doing that. If you can't afford it, when you get around to your next hearing, you can ask the judge to appoint counsel for you. But I've given you your next hearing date. You know what your bond is. You'll need to stay with the sheriff until such time as you are able to execute your bond.
And so we didn't address the jurisdiction issue either, right?
The fact that you're where you are and I'm where I am means that I have jurisdiction over you.
What is your name?
I am Brian. My family name is Wilkinson.
All right. We'll go on the record in State of Kansas versus Brian J. Wilkinson. Case number 25 CR 67. The state appears by County Attorney Darren DeVinny. Mr. Wilkinson appears in person by Zoom. We're here for a first appearance. Mr. Wilkinson, you're appearing by a summons. I'm going to go over your charges with you. There are 3 counts, all alleged to have occurred on June 4th, 2024 in Butler County, Kansas. Count 1 alleges you were in unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges you are in unlawful possession of paraphernalia for use. That is a Class B non-person misdemeanor. Count 3 is an allegation of possession of marijuana, also a Class B non-person misdemeanor. Do you understand what you've been charged with, Mr. Wilkinson?
I do not understand, Your Honor.
Yeah, what don't you understand?
I had thought that this matter was already settled on the case that Mr. Watts was representing me for.
Okay, I'm not aware of that particular matter. That may have been a different case. I'm not sure.
Well, there wasn't a different case. I mean, I wasn't attacked and assaulted and kidnapped 2 different times, just one time.
Mr.
And I've
Devaney, do you
already
know
been-
anything about another case involving Mr. Wilkinson?
Let's see. Well, I know there's criminal history. I know he's a B on the grid. He has out of at least Butler County cases, we've got a driving while suspended, an old 23 traffic case that's closed. And then he has this open case now for possession of methamphetamine.
Do you know of, is there one where Mr. Watts representing that you know of?
Not that I'm aware of. Well, Your Honor.
All right, well, I don't know, Mr. Wilkinson, that can be sorted out. Can you afford to hire an attorney to represent you?
I'm sui juris.
Excuse me?
I'm sui juris, and I would appreciate it, Your Honor, if you would recite your oath of office, your delegation of authority order, and your bond information.
I'm not going to do that, Mr. Wilkinson. Can you afford to hire an attorney?
I am not a ward of the court. I'm not an idiot. I know how to speak for myself.
Okay. Do you wish to represent yourself?
Well, I am myself. I can't represent myself, but yes,
I
will be talking for myself.
All right. You understand you have a right to have an attorney represent you on this case?
Yeah, but that makes me a ward of the court. If I am seen as too stupid to talk for myself.
Do you understand that if you can't afford an attorney to represent you, one would be appointed for you?
I also understand that all attorneys' first duty is for the court and not for their clients. So
do you understand you have that right, Mr. Wilkinson?
I do understand my rights, yes,
okay.
Your Honor.
I'm going to go ahead and appoint James Watts to represent you if you think that he's represented you on something that may be in line with this case. So he'll be with you when you appear back in front of me, and that'll be on my preliminary hearing control docket. Do you have something to write with, Mr.
Yes,
Wilkinson?
sir.
All right. Your court date will be in front of me by Zoom on May the 19th at 2:30.
May 19th, 2:30 p.m.
That's correct. Do you have Mr. Watts' contact information?
Yes, I do, Your Honor.
Okay. You might contact his office and let them know that court date. We need to set a bond. Mr. Devaney, what's your recommendation for bond?
The defendant does appear here voluntarily by summons here today, so I'd request a $10,000 OR bond for the defendant.
What was the amount?
$10,000.
All right, I'll set a $10,000 OR bond. He'll need to be processed, I'm assuming.
Well, he initially had a first appearance back on June 5th of 24 at 1:30. At that point, we were waiting on KBI Labs and we released him. So I believe he's actually been arrested and processed.
Okay.
He just needs to come to 201 West Pine. If he can make it here today before 5, that's great. If not, probably on Monday to come up to the front desk so he can sign his bond.
All right. Mr. Wilkinson, can you make it up to the Judicial Center this afternoon to sign your OR bond?
It'll probably need to be Monday, Your Honor.
Do you want me to start talking to people in the breakout rooms? I don't see anyone in the breakout rooms yet.
We're gonna keep calling. You can talk to Mr. Hicks right after I call this case.
Oh, very good, Your Honor.
All right, Mr. Hicks, are you there? I need a city attorney.
Yes, I'm here.
All right, this is the city of Detroit versus Albert Hemmer Hicks Jr. Case numbers SP 1442547, counts 1, 2, and 3. SP 1442765 1. And it looks like the rest of this stuff, then I have SP 1500871, and it looks like the rest of this stuff he's already entered a plea into all this stuff.
No, sir. No plea.
Well, that's not what it says here, sir.
I represent myself. I couldn't enter the plea. I never plea. You can check my record for plea.
Oh, maybe I found you guilty then. Yeah.
No, I haven't been. Matter of fact, I came inside there personally a week or so ago. And the young lady, the security officer, came out and said that I'm supposed to report today.
No, this is on some old stuff. All right.
I never entered the plea.
So do you not want the representation of counsel?
No, thank you.
Okay. There you go, Mr. Take, that's your first break of the day, Mr. Soroki, you know what I mean?
Judge, I know how to deal with everybody. So I said, I know how to deal with everybody, any type of client.
Yeah, I know, but he doesn't want it,
right,
so
I understand.
we can't force it on him.
No, I understand.
Yeah. So you can
take it as a plus.
So Mr. Lee, today is the date and time set for a show cause. As for purposes of arraignment, sir. We'll do it like this. I'll enter a not guilty.
Are you talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to follow the first one.
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
Yep, you should be down with area code now.
Mr. Hicks, for purposes of arraignment, I'm going to enter a not guilty plea on your behalf and give you a $0 bond, all right?
I object, Your Honor. That would be practice in front of the bench.
Say that again.
I object. That would be practice in front of the bench. Practicing law from the bench. You will have to recluse yourself if you hold on to that.
All right. Well, I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed if it pleases the court.
Deny. What basis?
You haven't even let me tell my grounds.
All right, basis. Give it to me.
For one, a ticket is a bill of attainder. Article 1, Section 9, Clause 3 of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You can have a written assistance.
All right, let me
stop. Equity that transmits into law penalties.
Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really, really, really bad, and we can't get that on the, turn your video off. Maybe turn your video off, that will help. Let's see. All right, try it now. Try it now, let's see. Go ahead.
Did you hear what I said?
Yeah, I'm listening.
Okay. Article 1, Section 9, Clause 3 of the Constitution of the United States. No bill of attainder or ex post facto law shall be passed. You cannot have a writ of assistance that has civil equity that transmits into law. Number 2, there is no sworn statement from an injured party. Number 3, the officer did not even sign the ticket. That's under law penalty of perjury. I'm asking that all of these be dismissed.
All right, I'm going to deny that motion. All right, how else do you want to proceed?
That's your declaratory judgment?
I'm going to deny the motion. I deny the motion.
Okay, let's go to court.
Trial?
It don't matter, because I don't understand how y'all run y'all system. Y'all practice against the law. I'm a common law.
Well, read the court rules, and you'll learn a little something.
The court rules go against the law. Y'all practice against the law, against the Constitution. I'm all common law.
All right. Well, we're beyond that.
Okay.
All right.
So you say. So you say. So are you going to prosecute this, or somebody else going to prosecute it?
Stop. Let's not keep going. All right. You want a trial date, or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to let's give them a jury trial date.
Jury trial?
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay.
Here's a. All right.
Scamming. With a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your respect for the court, but I asked the questions. I told you to read the court rules.
March the 5th. Let me check and see.
The court rules. What jurisdiction are you trying to charge me on?
Is March the 5th a good date for you, sir?
No.
Okay. We can do March the 19th. See how that looks for you, Judge.
Give him a little further out. So he can get his stuff together.
We can do May. You want to go all the way to May?
Yeah.
May 6th. No, let's do second Friday now, because I don't want it to collide with all your trials. I think we should do group 2. We can do June the 11th.
June the 11th is going to be the jury trial date.
June the 11th?
June the 11th. So let's put your final pre-trial date will be let's see, put that a day before. That way that'll be the date we'll argue motions on June the 10th. And I will want the motion filed, your motion filed by motions due by May the 24th. will be your motion, and now the
May
city,
24th.
May the 24th, and the city will have 7 days to respond. So the response to the motion will be due by May the 31st. All right, so we have your motions due by May the 24th. You make sure you serve the other side, and they'll have until May the 31st to respond. We'll listen, and I'll review the motions, listen to arguments on final pretrial of 6/10/2024 with a jury trial set for 6/11/2024 at 9 a.m. All right.
I appreciate you, Your Honor.
All right. Have a very good day, sir. Best of luck to you.
I just did. Thank you.
Thank you. All right. Let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Himmer Hicks Jr. Case number SP 1442547, counts 1, 2, and 3. SP 144-27651. Appearance for the record, please. And strike that. Wait a minute. SP 150-08721. Appearance for the record, please.
That one ours?
Yeah.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't license to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against
you. Okay, you have been practicing law across the bench since we started this, and I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer that's in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
That's so Mr. Hicks, you're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No. Don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay. So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a
I
license
thought about
to
that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to
again. All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you. Everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on, and I'm going to put you out, or at least mute yourself. Very well, officers. Be safe out there. Have a very good day. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
Record, Your Honor. Chiku Mason, City of Detroit, 434.
Yeah, something's wrong with your volume, Ms. Mason.
Oh, I'm sorry, Your Honor. It might be my mic is down. For the record, Your Honor, Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we gonna do? The officers were supposed to be here today. I'm only dealing with SP 15, SP 1442547, counts 1, 2, and 3, SP 144-27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're gonna make this easy. And now, what I don't appreciate is, you know, I thought about that comment that you made that last time. You know, basically, you're almost, it's almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. But all right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
I'm not threatening you. Say one more word and that's 30 days. 30 days.